We'll just wait a couple of minutes before we start. All right. Good evening, everyone. Welcome to Vidhi Book Adda. I'm Deepika Kinhal. I'm a senior resident fellow at Vidhi Center for Legal Policy, and I lead the judicial reforms vertical here. We call ourselves the Jaldi Initiative, Justice, Access, and Lowering Delays in India. At Jaldi, we undertake independent data-driven research to identify, study, understand, and hopefully solve for the systemic issues that plague India's justice delivery systems. Given our focus on the judiciary and our commitment towards enabling evidence-based reforms, I'm delighted to have Dr. Aparna Chandra with us today to talk about her latest book, Court on Trial, a data-driven account of the Supreme Court of India. The stated objective of this book, and I quote, is to make the opaque transparent and thereby to enable greater scrutiny of the court. And this the authors do beautifully and intricately through data at every step of the way. And that is what we are here to unravel. The book is co-authored by Aparna and Professor Seetal Kalantri and William H.J. Hubbard. Of course, Aparna is here with us today, and we could unfortunately not have the other co-authors. Aparna is no stranger to the community that we are all a part of, the legal research and law and policy community. But in case there is anyone else who has accidentally or deliberately joined, a quick couple of lines on her. She's a professor, associate professor of law at NLSIU Bangalore, where she teaches constitutional law, comparative law, gender and the law, and researches on judicial process reform. She has previously worked at National Judicial Academy, Bhopal, and founded the Center for Constitutional Law, Policy and Governance.
Thank you. Thank you for having me, Deepika.
Welcome, and thank you so much for joining us, Aparna. A quick couple of housekeeping rules. One is that we will be recording this discussion today, and it is getting live streamed on YouTube. If any of you have any objections to that, please do let us know. And second, in terms of making this as conversational as possible, I invite all the attendees to post their questions on the chat box. I will try and take as many of them as possible halfway through this discussion, say roughly around half an hour to 45 minutes into the discussion. I will look at the comments and questions. So please keep posting. I will also take one more round of questions towards the end of the discussion. And with that, let us just deep dive because there is so much to unpack, Aparna. It's been 10 years in the making, you say in the book, that it started around a decade ago, and you have created 5 new data sets to present to the audience. And as with the stated objective, the idea is to give credibility to some of the debates and discussions that have been happening over the last several decades, and also to sort of bring together various data points that have been put forth by research and scholars, especially over the last 1 decade, since the time that the judiciary in India at least has started putting its data out in a comprehensible manner. Now, while that has been happening, as you have also repeatedly stated in the book, that you are quoting from this particular study, and this is what has been laid down with respect to a limited point, I think what the book beautifully does is to show us the interconnectedness between various issues. The first time I read the book, I felt like each of the chapters and each of the issues that you deal with deserve separate book in themselves. But now that I reread it in bits and portions, I feel that you can tackle any particular issue only if you have understood the past and the potential future repercussions of the court moving in any specific direction. So therefore, I'm so grateful that you all took the bold step of tackling with all these seemingly very big issues in one go and in such an accessible manner. And we will come to the process that drove all three of you while you identified the data sets, while you identified the issues and how that went. But I think I will start with laying out some of the data points, looking at what they perhaps mean for the lay audience, then look at the solutions before coming back to the process. And let me start with one of the more controversial ones, right? You start the book with questioning whether the Supreme Court is actually a people's court. You lay down the basic data with respect to that, which is that the court is actually entertaining 60,000 cases every year on an average. It is in that admitting on an average 10,000 cases. It is publishing around 1,000 odd judgments. And all this with the highest strength of the court being 34. It is quite a lot, right, for each individual judge as well as the institution as a whole. So if you look at just these numbers, it appears that yes, of course, Supreme Court is the people's court, right? It is giving access to so many cases. It is giving access to so many people. And then you question this premise and go one level deeper to identify what are these cases, who are bringing these cases to the court, and who is arguing this matter. And in that you say, okay, these are mostly special leave petitions. 92.4% of the cases are special leave petitions under Article 136 of the Constitution. Then you go on to say that most of these special leave petitions have to be brought before the court by senior advocates because the chances of this converting into positive outcome is doubled if a senior advocate is the one arguing the case before a Supreme Court judge. Then you also showcase that, with 60,000 cases being filed, advocates on record who earn their living on a case-to-case basis are also benefited. So on the one hand, you portray the picture of court actually being accessible to a lot of cases and a lot of people. Then you also go on to show that senior advocates and advocates on record who are, sort of the primary members of the Supreme Court bar, they are also benefiting. But then you go on to conclude that the Supreme Court has got it all wrong. It's not really a people's court. Can you explain that to us?
Sure. First, thank you so much, Deepika, for those kind words, both about me and about the book. And I'm particularly glad to be talking to you today because so much of the work that you and your team do is very complementary to the kind of work that we have in this book. With that, let me just jump right into the question. Now, we all know, we who study the courts know that in the 1960s and the early 1970s, there was a lot of criticism of the Supreme Court that it was very inaccessible. It was, and in, Keshwanand Bharati, perhaps the best known judgment of the Supreme Court, one of the judges said that, we are criticized for being a forum for the legal quibbling of men with long purses. Right. So this idea that it was an inaccessible court and it wasn't, it was looking at the work, whether princes were getting their rights protected, whether those who held property were protecting their property rights were being protected of landlords and things like that. The common person was losing out. And so towards the end of the 1970s, of course, there's the entire criticism of the court in terms of how it, really capitulated to the executive during the emergency. So subsequently, a few judges of the Supreme Court very self-consciously tried to recreate the image of the court. That's what they've said, at least. I mean, they've said so in their in the writings that they've done, and that is in fact what happened. Where they try to make the Supreme Court more accessible. right? And that's where they introduced the PIL system, so that anyone who's aggrieved, who's aggrieved but cannot go directly to the Supreme Court, can have someone else represent them in the court, so on and so forth, right? So the public interest litigation movement, which becomes such a important face of the Supreme Court, starts at that time. Another thing that happens around the same time for the same reason, but hasn't been remarked upon as much, is that the court starts taking on many more appeals, right? And that is through that special leave petition. So we have quoted in the book, but if you look at some of the judgments coming out of the Supreme Court around that time on the special leave petition sort of route, they start talking about how, again, the very similar language to PILs, to say that we have to give access to everyone who feels that they've been wronged, and wipe every injustice, so on and so forth, right? In that sense, the court tries to project itself as a people's court. And in that sense, we say that the court remains a people's court, right? It is trying to give access to the Supreme Court itself to the largest number of people that it can, and particularly to those who are disadvantaged. And in that sense, it remains a people's court. Now, so in that sense, we are countering one kind of narrative against the court, which is that from the 1990s onwards, the court turns away from this people's court attitude, because people who are the most vulnerable start losing out more before the court. And we say, no, in fact, what the court is doing is it's favoring the same groups for access to the court, so that what it is doing is it's taking on weaker cases from these groups, and giving them, therefore, a priority in getting access to the court. But once they come into the court, because they have weaker cases, they don't lose they don't win as much. So in that sense, in terms of giving access to the Supreme Court, they remain the people's court. However, that access to the Supreme Court is not the same thing as access to justice. And unfortunately, it appears that the court seems to conflate the two, right? Access to justice for the bulk of the people is access to the lower courts, or maximum up to the high court. And one consequence, perhaps an unintended consequence, but a consequence on taking on so many matters at the Supreme Court level, is that it is impacting the ability of people to get good quality justice lower down the order in the High Court and in the trial court. That both creates a vicious cycle where people want to keep going up to the Supreme Court more and more, but also limits the ability, that creates, that whole problem of polyvocality, that the court is speaking in multiple voices, creates the problem that there's very little certainty in the law, and therefore creates the conditions for not having good quality justice at the lower levels. At the same time, it crowds out the most vulnerable sections, because people who are the most vulnerable are generally the people who cannot afford to wait for long for justice. And we talk about the systemic effects on delays in the Supreme Court because of the burden of cases that it takes on. Now, all of this might be understandable if the court had very good selection criteria, and just that, it needed to take all of these cases, it was taking all of these cases, and perhaps the only thing that is to be done is to increase the number of judges, or do something, make the processing of these cases more efficient, but not a question of not taking these cases. But if you look at what the court is doing, we found that of all the cases that the court takes, it reverses only about 57% of cases, right? It's barely better than flipping a coin. That seems to suggest that first brush, 2 out of its 5 days that it spends on admissions, it's not necessarily doing a very good job of filtering out cases. And so it has a very, very low reversal rate. You would think that the Supreme Court at its level, if it's taking on a case, there should be something that's so profoundly wrong that the chances overall that the courts are that the low courts were wrong would be very high. But overall, it's only about a 57% reversal rate. So that seems to suggest that the court does not have a very good filtering mechanism. In fact, we found that number, a bulk, and I'm forgetting the number directly, but if I remember correctly, about 60% or 64% of all the cases that the Supreme Court takes on the SLP route are cases where all the lower courts have agreed on the outcome, right? And the Supreme
Right.
Court has
Right.
still entertained that matter. And when the
Hmm.
Supreme Court entertains matters where all the lower courts have agreed, it has, I mean, it's not surprising, but it is 20% more likely to
Hmm.
to hold that the lower courts were right. Right? So it
Hmm.
just, I mean,
Hmm.
just seems to suggest, all of this is to say, just seems to suggest
Hmm.
that there is a problem with the filtering mechanisms that the court has in
Hmm.
place. The court's taking on a lot of cases. Very often, these cases are not raising any novel point of law. The court is not discussing any novel point of law. It is taking another look at the case. And someone
Hmm.
suggested to us as a phrase that we found very useful, to say that what the court is interested in is not systemic justice, but case by case
Hmm.
rescue. Right? In this case,
Hmm.
if we find something unjust, we will rescue these parties from it. And that does not make for a good, accessible system if we think about the Supreme Court as just one part of a larger judicial system. So that's the point that we're making. That if you're
Right.
interested in access to justice, then how
Hmm.
can you reform your working so that people can actually get access to justice and not just access to the Supreme Court? So, in those senses, we
Right.
say that the Supreme Court is no longer a people's court because it's not enabling
Right.
access to justice for people. It's enabling access to the Supreme Court for a particular group of people. And just to finally close out on that point, to say that because it has such a large crush of cases, it also
Hmm.
needs that it has a limited ability to actually process these cases. So in processing these cases, it relies on proxies to decide, what is it that we should entertain and we shouldn't entertain. And one of the proxies is who the lawyer is. And so the face value of the lawyer and senior advocates, therefore, who are more reputed members of the bar, handpicked stars of the court, either by the Supreme Court or by the High Courts, get preferential treatment in terms of how likely it is that their cases will succeed, at least at the admission stage. And so that means that they can also command a premium because of the face value they bring before judges. And that again, if your gatekeepers to the Supreme Court and to accessing the court are the most expensive lawyers perhaps anywhere in the world, then obviously you're not creating a very accessible system or people's system in any case.
Right. Now, to explore the human angle that you presented towards the end, Aparna, which is that there are these grand advocates, as they are now even popularly being called, act as gatekeepers. And there is obviously this extremely lucrative financial angle involved over there. And parallelly, we know that the court's current approach is making it popular. And you quote, and quoting from your book, you say the court is currently popular and admired in India and internationally, given that it takes on so many cases every year. Given these realities, uh, do you think the solutions that you present, and the solutions are twofold, right? One, you say there should be a better filtering mechanism wherein the court identifies that it will take on only those cases which have some intense legal argument to be made, or does or chooses not to take on cases where the lower courts have consistently decided in any particular way. And then, second, you go on to say that with respect to senior advocates, they need to be given a different kind of mandate, which takes into consideration the higher legal acumen that they are known to possess. Uh, However, who would rock this boat, right? Which CJI, irrespective of the tenure, be it long tenure or short tenure, would anyone be willing to take on this challenge of actually trimming the court's scope, court's mandate that it has currently drawn out?
Right, and that is really, we can present all the data that we want, but it's the political economy of this court that's really going to rule the roost. And the people who benefit from the system are the most powerful in the system, and obviously they will not want their power to go. It's interesting, therefore, that even the policy solution, I mean, I think everyone recognizes that something has to give. I don't think it's a question of people not even recognizing that there's a problem. In fact, we actually begin the book by saying that, it's very interesting that every time a chief justice comes, takes charge, And in that first interview that they give to the media, the first question that they talk about, or the first issue that they talk about, is their plan for reforming the court, right? So I mean,
Right.
everyone's agreeing that there is some reform that is required, that business as usual is not enough. The question is, what is the direction of reform, and where the impetus will come from. Now, one of the things that the court has been considering, in fact, there's a case pending before the court, ironically hasn't been heard in the last 5 years, but is pending before the court, is about the creation of a national court of appeals. And I'm guessing that the impetus for that comes from the idea that, okay, you need to give all these lawyers some work. So just shift the site of that work, and then the Supreme Court can turn to the more important things that it has to do. Um, and we talk about how that might not be a good idea, because you're just shifting the site of the problem, not dealing with the problem itself. But on the other hand, this idea that the SLP jurisdiction is something where you might need some kind of guidelines. So these are not, guidelines in any case are not going to be such strict guidelines as, in the nature of a checklist or something of that sort. Obviously, there will be a lot of interpretive play available, but the idea that you have some guidelines for the court to sort of look at, and for lawyers to know that here are the ways in which you convince the court, here are the parameters by virtue of which you convince the court that this is a matter worth taking, is something that has been mooted on the judicial side in the court itself. In fact, it went up to a 5-judge bench, and in 2016 or 2017, the Supreme Court refused to interfere. So just to say, I mean, it's not just a question of, on the administrative side, the Chief Justice of India looking into this matter, but also on the judicial side, right? Where possibly, again, if a judge is looking to blunt the force of reform, blunt the pushback, then this is something that might have to be done on the judicial side, and that's something that's an approach that is available. The second thing, which has actually started happening since we finished work on this book, is, at least for the Constitution bench, there is a move towards documentary advocacy. Now, our court system and our judiciary historically has been very much focused on oral advocacy, and there are a lot of historical reasons for it. And it might be a good reason to retain that kind of a model at the lower courts. But at the Supreme Court, where anyway accessing the court requires you to access it through an advocate on record who has been certified by the court to possess filing, the requisite filing and drafting skills and the know-how, it is there's no reason why we can't shift to a majority documentary practice with a limited oral component. The idea that somehow access to justice and access to the court requires that every case has to be heard for any length of time and heard orally is something that really needs to give way. I mean, in an ideal world where we had no resource constraints, obviously we should have as much time and as an in-depth an inquiry into every case as is needed. But given that there are resource constraints, one has to make some decisions and some trade-offs between, a oral only or a oral heavy advocacy culture versus a documentary culture where you base decisions on documents, and you do oral hearings only for clarificatory purposes in a time limited manner, etc., which will blunt some of the right now the face value that senior advocates have before judges, where most of the decision is happening elsewhere. Obviously, now courts, it's not as if the judges are deciding, on their whim at the back end, and you don't really get to know why they're deciding these cases, because judges have to give their decisions and their opinions. Even today, in terms of admitting or dismissing a matter, judges are not, even when they hear lawyers, they're not giving you any reasoned order, right? It's a one line, admitted, dismissed, so on and so forth. Very rarely do they give you reasoned orders, and they just don't have the time for it. So if that is the case, if it's not as if you're getting a reasoned order in any case, it is not evident to me why we cannot shift to a more of a documentary culture as opposed to the one that we have right now.
Right. And I think in this aspect, the Supreme Court is treading on the right path when it comes to constitution bench matters. Maybe it is the pressure that comes from live streaming and transcription of cases now, where every word is recorded and every word dissected out in the open. There seems to be some internal discipline that is being brought into the court dynamics in terms of the questions that are asked, as well as in addition to documentation driven process, there are also time limits being imposed. And in fact, Indian judiciary and the Indian Supreme Court happens to be one of the very few who continue to not prescribe outer time limits for case hearings. Most of the jurisdictions, US, UK, Australia, and even smaller jurisdictions for that matter, identify an upper cap on the number of lawyers who can argue, as well as the time for which they can argue. Only in India, you have a barrage of lawyers, a dozen odd per case, and each of whom end up taking at least an hour. But that culture seems to be slowly changing. So therefore, I think change is not as far away or as distant and improbable as it used to appear earlier. However, it still seems to be very, not really tokenistic, but very individualistic. This ties in with the point that you made, Aparna, that each Chief Justice comes in and showcases that these are his mostly, not her until now. These are his, priorities for the tenure that he has, and goes around tweaking a few processes, bringing in a few reforms, all of which can be immediately reversed by his successor. Right. And that has actually been the bane of the judicial system. We don't have really a comprehensive picture as to the direction in which the judiciary is headed on any of the issues that you identify in the book, or even, larger set of constitutional mandate that they have. Picking on one of the points that you make, Aparna, regarding constitution bench matter, which you identified as pending for more than 5 years, and drawing from there to who is there on the constitution bench. That is one of the other controversial points that you make in the book, and that to me is one of the most hard-hitting data points that you have. Your data sets clearly show that, one, there is no rationality in the way judges are assigned to a constitution bench. Constitution bench matters, as we all know, is under Article 145(3). They are constituted to deal with most significant of legal and constitutional questions that the court handles. Therefore, it is important for the public at large to know who is deciding those cases. And you would assume that there would be some guideline, some rationality with respect to who is coming and sitting there as part of those 5, 7, and 9 judge benches. But you say that seniority is not one of the criteria which is driving. Your data shows that seniority, in fact, has nothing to do with who gets to sit on the bench. What, in fact, seems to be driving the bench composition is who the master of the roster is, which is the CJI, and what their interests are. In the sense, you showcase through data that mostly it is the judges who they have appointed while they have headed the collegium who find a place on the constitution bench. And you also show that consistently CJIs become part of the constitution benches, even though that is not really a necessity. CJIs needn't be part of the constitution benches, but they invariably are in most of the cases. And the other interesting factor is the CJIs are always in the majority opinion, right? They hardly are in the dissent, which showcases that perhaps they are influencing the outcomes by the manner in which they are picking and choosing the judges who will be part of the bench. Now, the solution that you offer to this is again something that has me curious. And I'm questioning the feasibility of it, right? CJI takes these decisions, he is master of the roster, and you're asking him to curtail his powers. How do you think this will play out? And this I ask at the back of a quick data analysis that I happened to conduct, which I shared with you recently. Even in this particular CJI's tenure, this is playing out. A judge who was elevated in January 2023 finds himself on 10 constitution bench matters. So this seems to be a trend across all CJIs. Again, will the CJI himself take a decision to curtail his powers, bring in some checks and balances? What do you think is likely to be the reality?
Right. Let me say something about our data point, and then to the solution that we are advocating. So we found two very interesting things, right? One thing we found is that the Chief Justice is on about 88% of the Constitution benches. Now, you would imagine perhaps that's because, the Chief Justice appoints the senior most judges on the Constitution bench, and since the Chief Justice is the senior most, they're likely to be on the bulk of those matters. Except the Chief Justice is 4 times as likely as the next senior most judge to be on the Constitution bench. No other judge is on the Constitution bench as much as the Chief Justice is. So clearly the Chief Justice is over-assigning Constitution bench matters to themselves, right? And again, to reiterate your point, these are the most significant and salient matters pending before the court, right? So the Chief Justice gets to over-assign overassigns themselves to the benches. Now, okay, but maybe there is some other, metric by which they assign other judges, and the Chief Justice is one amongst, 5 or 7 or 9 judges on the bench. So how does it really matter? Except we find that unlike any other judge, no other judge can do this except for the Chief Justice, who is almost never in dissent. So we found between 2010 and 2019, where we did a study, the Chief Justice of India was in dissent in one constitution bench. Right? Remember, he's in 88% of all of these cases was in dissent in one, and that one case, which is the triple talaq case, happened to be a judgment that was given on the last day of that Chief Justice's tenure. In fact, again, Nick Robinson, who's looked at this, studied this looked at all constitution benches from 1950 to 2011, found that the Chief Justice from 1980 onwards had been in 1,500 odd constitution benches, had been in the dissent in less than 10. Right. So, I mean, and this is a problem that's happened from the very beginning. The Chief Justices over-assign cases to themselves, and then the bench that they have constituted happens to be a bench that almost always sides with the Chief Justice in terms of the outcome of the case, right? So this just goes to show that there is something happening here where the Chief Justice, who has the power to constitute the bench, also ends up constituting the bench in a way that they happen to be on overwhelming majority of those benches, and they're never in the minority. They're always in the majority. They're always carrying the majority with them. Right? So that just goes to show that there is strategic assignment happening. So in that sense, there is a rationality, right? But the rationality is outcome driven rather than anything that is about any other objective criteria that could be ex ante applied regardless of the dispute at hand. So the solution to this issue. Now, in 2018, if you remember that entire press conference that happens against Deepak Mishra, assigning what appeared to be Judge Loya's case to a relatively junior judge, and the 4 judges come out and do a press conference on it. That was a master of the roster controversy, and subsequently 2 cases go up before the Supreme Court, and both of them, one is filed by Shanti Bhushan and the other by someone called Ashok Pandey, and both of them suggest that there has to be some mechanism right? And the court,
Mm.
and Shanti Bhushan's petition says that, the collegium should be making these decisions. The court, and I think rightly, rejects that, saying that, there are just so many questions around assignment of cases, on a day-to-day basis. Some judge has to recuse themselves, some judge has fallen ill, the case has to be given to someone else. I mean, there's many permutations and combinations. This kind of marking of a case to a different bench or a different judge is a daily activity, and you might not be able to get the collegium to be able to do that kind of work on a daily basis. The other argument, which was the argument made in Ashok Pandey, was to say that we need some norms, some guidance, or some mechanism by which there is some transparency and accountability in the system. To which the Supreme Court said that, you should trust high constitutional functionaries like the Chief Justice,
Mm.
and not sort of, and trust that they will do the right thing. Now, obviously, and our data is showing that that trust might be misplaced. So the question is, what do you
Mhm.
do? And we said, and where we're coming from is by saying that, this is an administrative power. This administrative
Mhm.
power should not be impacting judicial outcomes, but it is. If that is the case, can we look to administrative law, which has all of these rules for bringing accountability in the exercise of discretion, right? Administrative discretion. And can we use those rules? So, for example, one of the rules is, it's not as if administrators don't have discretion, but how do you ensure that their discretion is not just, acting on whim? Is by saying that there are some principles that you adhere to, and you apply those principles, but you could override those principles, but only for, say, reasons to be given in writing. So that's the approach that we are taking. Will chief justices have the incentive to curtail their own powers? Realistically, I mean, a lot of what we are suggesting in the book will require that kind of a will, right? A will to change. And the idea behind the book, and the idea why we've written it, we've gone with Penguin as our publishers, and we've written it in what we hope is an accessible style, is that if this conversation is taking place not just within legal circles but out in the open as well, that the court feels the need, at least the external pressure, to reform itself internally. And that's perhaps where the pressure will come from, with the idea that people start questioning more and more, why is it that we see the kind of constitution bench constitutions, the constitution of constitution benches that we are currently seeing. More realistically, you're probably going, if you even see a movement on this, you will see it towards the end of the term of a chief justice, when it is no longer
Mhm.
about curtailing their own powers, but that of their successor. I'm guessing that is how a
Mhm.
lot of institutional change happens. um,
Mhm.
and perhaps realistically, that is where you will see, either with a short-term chief justice, or if a chief justice who has a longer term, then towards the end of their tenure, when it's not going to really curtail their own powers, is when you might start seeing some of these changes happening.
Here's hoping that comes true. Uh, we have a year more to see if that happens. But this entire resistance to change seems to be all pervasive, and that is quite ironic, right? Given that the institution is supposed to uphold constitutional values, and day in day out through umpteen number of judgments, it preaches the same to the government. Yet internally, most of the Supreme Court's administrative processes are opaque. And this is what I think comprehensively the book tries to draw attention to, right? Who are the judges deciding? How are they deciding is not even dealt with. It is about how are you appointing these judges? How are you deciding what cases you will take on? How are you deciding to allocate the precious judicial time across different matters? Right. So these are the questions that I think the Supreme Court or the judiciary ought to have answered for itself by now. But there seems to be that resistance against accountability, against transparency. And this is something you again state in the book, which is that only if you lay down the standards will you be held accountable for it. So I guess the easier route
Yeah.
is to not lay down the standards. However, this is also linked to the tenure of the chief justices. right? This is a data point again that you bring to fore, that on an average, chief justices have around 9 months, and it is getting shorter and shorter. The judges themselves have an average tenure of over 5 years, and the CJI even lesser, who is the one who is going to be taking these policy decisions. So once this judge reaches the topmost position, perhaps the incentives are all, misaligned to what the system actually needs. And in this, you take the reader towards the appointment process, right? When are they getting appointed? Who is getting picked up? And why the current collegium system may actually not be serving even the profile of judges that it seeks to favor, even if it is an upper caste male judge. The collegium system actually is not putting them in a position of making sound long-term decisions. And the other fallout of the current collegium system is the angle of diversity, right? When it comes to gender and caste diversity, it hasn't been able to push the boundaries by any extent. It hasn't kept pace with the government for sure, where through reservations and through affirmative policies, at least caste-based representation has increased at all levels within the government. But within the judiciary, it has stagnated, and in some instances, gone further down. Um, and again, here, there is no dearth of lip service. If you ask any CJI who has recently taken office or retired judges, they keep talking about wanting to increase gender diversity, wanting to make the system more representative. So why is there this, lack of action once people are in power, and all the other interconnected issues that are at play, which you beautifully present in the book. So I leave it to you to, bring that to the fore.
I think so. One, of course, we have to realize, for example, when it comes to caste, that the judiciary has, in a very self-serving way, itself exempted itself from reservations, right? So it's coming from, where is the judiciary, the higher judiciary's exemption from reservation coming from? It's coming from Indra Sani. So the Supreme Court has given its own judgment to say that, the higher judiciary is exempt from reservations. I think fundamentally, one has to ask, it begs the question, why do you need diversity in the judiciary, right? And that goes back to the point that I was making about the master of the roster, because who the judge is very often determines what the outcome of the case is. We know as lawyers that law constrains, but it doesn't fully constrain, right? I mean, there is a lot of leeway that a judge has to decide in a particular way how they understand facts, how do they look at a question and decide, whether a dispute is made out, not made out, what do those facts reveal, whether the fact is something that is reliable, not reliable. Can I trust your evidence or not? Or are you likely to be lying because you're a woman who's talking about sexual harassment, so on and so forth, right? I mean, that really depends on the worldview of the judge, and that worldview is shaped obviously by your social location. So, which is not to say that only social location shapes your outlook, but you're likely to get a more diverse kind of viewpoints on the bench if you have a more diverse judiciary, right? So just in terms of creating a more creating capacity within the judiciary for greater diversity in terms of its output, you require a more diverse bench. You're more likely to get that diversity than otherwise. So if that is the case, then we really have to ask the question, what has been the history of the courts of in the appointment process, or at least in the higher judiciary. your study, I mean, Vidhi's study, and I think you were leading the team, if I'm not mistaken, has looked at the lower judiciary, right? And you've looked at your studies, and again, you should be possibly talking about that, about the value of reservations in particular, but the value of diversity in the lower judiciary. I mean, it's pretty stark what's happened in judiciaries across the country on gender and on caste. But in the higher judiciary, we find that the higher judiciary, in fact, you would have expected there to be increasing representation of women and caste minorities in the higher judiciary, just because more and more of them are coming into the system and are becoming more senior in the system. In fact, so if you take a time series in that sense, or you expect that over time this would increase, that's actually been the opposite, right? It's not kept pace with the growth of the diversity, growth in diversity of the legal profession from where judges are drawn. So that's one thing to keep in mind. Why is that the case? I mean, we also, again, we have a system that's sort of set up for failure in that sense, because you have the most privileged within the judicial and the legal circle who are deciding who the next set of judges will be, and this obviously will depend, and they have no accountability in terms of even putting out the reasons for why they are preferring one over another, or having any kind of transparency whatsoever, just in terms of what is the pool that they're looking at, who are they considering, or what are the norms that they're looking at. I mean, even if it's not about persons, but the norms by which they are making these determinations, or asking for applications, and then and nominations or applications, so on and so forth. None of that's happening, right? So as a result, you end up in a completely opaque system where decisions are being taken by the most privileged within the legal community on basis that we don't know anything about. Right. So that's one part of problem. The other part of the problem is a more cultural problem, right? If you speak to judges, or even if you speak to senior lawyers, they will often say that, if you bring in too much transparency into the appointments process, then people will not apply. The best kind of candidates will not apply. And that, to me, is a bit of a puzzle, because that may be the case. It may be the case that we've gotten so used to this kind of an opaque system where we are invited to become a judge, and we don't have to, and it is beneath us to actually apply for this position, which sounds quite absurd to me, because this is a public office, right? And why is it at all beneath a person to apply for this? But again, if you look globally, if you look around the world, the Indian system is a very unique system. Around the world, there are kinds of controls that the public has. There's level of public scrutiny, or scrutiny through a commission, whose internal sort of deliberations might be made available, etc., where there is greater public scrutiny. And I mean, I don't know that we need to buy into that idea, that we need to pander to this notion that judges should be invited, and they cannot apply, and somehow applying is beneath them, and we need to pander to this notion that applying for a judicial office is beneath a person, so on and so forth. Or that transparency, that if you apply for a public office, asking you to sort of go through some kind of a rigorous process is beneath them. So I think there's a large part of this that's a legal culture problem that we really need to sort out, because we don't hold these requirements as being at all relevant in any other kind of public office in India, and we don't, and globally this is really not how we think of judicial office, that it's somehow such a privileged office that there is no sort of accountability for who gets appointed. So I mean, I think placing it in this kind of a comparative perspective, I think, gives us a greater sense of where this is to come from. Again, my solution to this is more about norms. Explain the norms by which you are have more detailed norms for application for judicial office, invite applications. And again, this is something that's happened with senior advocates very recently in the last few years. No reason why it can't happen with judges. Apply for, have clear norms, set those norms out in advance, have an application based process or even a nomination based process where the person who's nominating has to indicate why why a candidate meets those requirements, etc., etc., generate justification by virtue of those. I mean, so there are ways that this can be done. Unfortunately, the moment there is any sort of conversation around this, it becomes a question of judicial independence. And just like with access to justice, right? The idea that because we need to provide access to justice, therefore you cannot curtail any kind of, put any constraints on the Supreme Court. Similarly, because you need to protect judicial independence, therefore you cannot ask for any kind of accountability or transparency in the appointments process, seems incredibly bizarre, but that's been the tenor of the judicial discourse, at least, on this question.
Yeah, broadly, it's very ironical the way the judiciary functions. And that, as you rightly said, comes from this very almost like a divine theory driven understanding of who our judges are. They can do no wrong is something that they have told themselves. Of course, the public narrative, the public impression seems to be surely changing, right? With the advent of social media especially, there is, and also live streaming, better access to courts proceedings and data, day in day out people are questioning who our judges are and how they are deciding. So the sooner the court realizes that they are up for scrutiny and sets the house in order, the better for them. No longer can they, I think, continue to shield themselves with this aura that they have built around themselves, right? And
in fact, no, go ahead.
Please.
I didn't mean to interrupt. Okay,
No,
so I was
please.
just saying that, in fact, the idea of the, quote unquote, majesty of the law and majesty of courts, this language that has very often been used to talk about the elevated status of courts, so on and so forth, has depended quite a bit on this mystification of court processes, the mystique associated with courts. There's actually very interesting literature, both in India and from around the world, on just the architecture of courtrooms, the idea that judges are sitting at that elevated platform, the architecture in colonial court architecture of this imposing court buildings, etc., to show the majesty of the state through the majesty of the courts, and thereby sort of to overawe population. Right now, obviously, that has changed quite significantly, and there's again some very interesting literature on sort of the visual representations of courtrooms and justice, etc., which changes with greater democratization. But more to the point on live streaming, I think that's very fascinating that we're already seeing conversations within the judiciary where about okay, we should be careful what we say from the bench because people are listening, people are seeing us, so we need to control our demeanor. We can't be very autocratic or very imperial in how we approach these cases, how we speak to lawyers or to litigants, so on and so forth. And that's precisely what you want. That's precisely the benefit of live streaming. So of bringing the people into the courtroom in a way that hasn't been possible so far.
Right. And speaking on technology in judiciary, we have a question on that. One of the attendees has posted this, and I'll read it out for you. Can AI be used with some pre-designed format for issues raised and decided at each level, including at SC, rather than long-winded judgments where the issues are often obscured and lost? Maybe that can bring some transparency in decision-making. Further, a group of retired judges or some mixed body of lawyers and judges do a critique of all decisions, at least at SC level, whether in public or in private. And these are then reviewed on SC's own accord. So this is about bringing in some algorithmic way of condensing the judgments and then also scrutinizing those judgments so that they are more palatable, or at least they are checked by the Supreme Court before they are published. On this, and then generally, Aparna, on bringing in some AI driven tools on scheduling of cases as a solution to some of the issues that we have discussed in the first part. What is your opinion?
Okay, just to say, I think there is a lot of benefit from technological advancement in sort of increasing the efficiency of court processes, and perhaps at a default level, just in terms of how you're doing your case assignment, so on and so forth. But I come from a position where I want to ensure that for decisions that are so consequential, there is an element of human oversight. And so in terms of increasing efficiencies in just the sort of the bureaucratic processes, administrative processes of the court, perhaps there is a lot of value for technology, whether it's AI or other kind of technological efficiencies. That's fine, but it should be subject to human override. Having said that, on the judicial side, I should say, a bit concerned about the ease with which language around AI and has been incorporated into at least conversations around increasing on the deployment of AI in judicial processes, on the judicial side of things. And I'll say why. One is, we know that law is not mechanical. We know that law is not objective. It's a question of interpretation. Interpretation itself is a creative exercise. It is not just a question, there used to be the sense that law is, what judges do is to take a law that is very evident and take facts that are known and match law to facts. And if the law and facts match, then you have one decision. If the law and facts don't match, then you have another decision. We know today that that's not how things happen, right? What are the facts? What are the relevant facts? Have the facts that are alleged to have happened actually happened? Have they been made out? Questions around evidence, all of those things are really questions around where judicial discretion comes to play. Similarly, with the law, what is the law on a particular point? What is the best interpretation? That question is not a mechanical question. That question is not a question of just looking at a string of previous judgments and therefore saying that there is just one conclusion that's possible. If that were the case, you wouldn't have two sides and two strong sides to every dispute. So having said that, for that reason, the use of something that is more algorithmic and that might therefore is to my mind something that requires a lot of caution, because what it can do is it can have a bias towards the past. Right? So it can have a bias towards patterns that you've already observed. To give you an example, in the US, where AI tools have been used in making bail decisions, right? We put in input a range of factors and therefore come out with a bail decision where, is this person, given these characteristics, likely to be a flight risk? Is this person someone that we can trust to not, skip their bond, so on and so forth? And it's been found, obviously, that many of those decisions are based not on the individual considerations of who this person is, but on extraneous considerations such as the person's race, the geographic location that that person stays in, which maps onto very often, obviously, the economic circumstances of that person, so on and so forth, right? So there's an element of being judged not for who you are, but what your associated characteristics are, plus not being, taking the injustices of the past and encoding them into the law through algorithmic processes. So for those reasons, I would be very skeptical of using these kinds of technological sort of tech elements in um, making of decisions, right? There might be space for simplification of decisions. Once you've done, the future is going to be that, right? That you have a human interface with with AI, and you would have to keep having that back and forth, and perhaps simplifying the language of a judgment, or putting out a version of the judgment in a one pager on a particular judgment, which still would require the judge to apply their mind to that simplified sort of decision. But at least, the first draft of it may be AI generated. Maybe there are possibilities there, but I would be very skeptical at every stage where there is a tech involvement, to come at it with a mindset that says that, that tech will solve these problems for us. I don't think that is going to happen. Tech may increase some efficiencies, but it should be seen as just that. It should be seen as a tool, like we have a pen as a tool, like we have Google as a tool. It is a tool, but it requires a whole range of sort of interactions. And unfortunately, what's been happening, at least in judicial discourse, at least discourse on judicial reform, is to somehow sort of believe in a kind of tech utopia, that the more tech you throw at a problem, the better, the easier that you will solve that problem, without
Yeah.
necessarily stepping back and saying, what are the consequences of bringing in this tech? What is it disrupting? Is it disrupting something that it shouldn't disrupt, right? There's good disruption, bad disruption, and we all for good
Mm.
disruption, but we should be very cautious. So I would just advocate caution for these range of reasons.
Right. And tech somehow is seen as an end in itself. It is not seen as a means of addressing the underlying issues, which is why you see that despite the eCourts project, which has been in the work for the last decade and a bit, there isn't much that has changed on ground in terms of how the judiciary functions. In fact, in one of the speeches by a retired High Court judge, he was saying how, if you enter a bank today, it is a world of a difference when you compare it with banks in 1990s. You enter a hospital today, a doctor who was there a decade ago wouldn't be able to function. But you bring a judge who was in 1950s to a court today in India, he would still feel very much at home. So to that extent, in our processes, our way of administering justice has hardly changed, despite umpteen number of technological solutions being live. Right, you have the hardware, you have the software, but things haven't really changed much, either in terms of efficiency or in terms of experience of accessing justice. Right, both of them continue to remain extremely complicated, which adds to the mystique, as you rightly described. Therefore, yes, I think hopefully as we go forward, technology will be seen for what it is, which is an enabler and not something that needs to be glorified unnecessarily. And I think that is also, the in terms of the underlying intent, the book also adopts a similar line of argument, right? You don't have to go big with reforms. It needn't be populist. It needn't be a magic bullet solution for everything. What you and your co-authors have attempted to do is identify those, uh, clear-cut processes which run across the entire justice system, wherein you tweak this a little bit, you bring in transparency a little bit over there. There is going to be an impact down the line. However, do you think this judiciary is actually looking towards solutions such as this, especially given that most of the CJs end up having short tenures?
I mean, that is precisely why some of these smaller solutions might be more workable than this. There is no magic bullet solution. This is a complex institution. It's a human institution that deals with some of the most complex problems that human beings have. And as such, having one single solution is not really going to be uh, 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 possible, precisely also because people don't really agree on what the problems are in the first place. We think that taking on so many cases where which don't require the court to uh, to lay out any new guideline, or which don't have any unique factor that doesn't really even require any engagement with the law, is a bad thing. There be others who will not agree with that. We think opacity in the working of the court and its administrative processes is a bad thing. There might be others who think that it's very crucial for judicial independence. So we have it's a large institution. Some of the strengths of the institution come from the fact that it's a large institution. There's no certainty as to these the problems. There is no sort of one view on these problems, and clearly there's no one view on the kind of solutions in that ecosystem. One, no magic bullet solution is possible, but also it's not desirable. You don't want a system where you have one chief justice who comes in and says, okay, I am now going to turn the entire system on its head. That's a very autocratic sort of way of functioning, and less than desirable. If that is the case, then these small minor changes, is this incrementalism in policy,
Mm,
might, I think, complements evidence-based policy reform, right? You make a
mm,
small tweak, go where the evidence leads you. Don't just, the evidence can point to some problems, the evidence might not be able to point to all the solutions. You don't sort of overhaul the entire system overnight. You take incremental steps, step back, look at what the evidence is now, and then make those changes incrementally, right? And that's how the bulk of our policies are generally made. So it's not nothing unique that we're talking about. With that in mind, we've made sort of these smaller these suggestions, some low hanging fruit, some which require political will, or at least judicial will towards change, but don't require necessarily some such a blockbuster change that you have to that there's a lot of political capital that has to be put into that process. And that, we think, is both a more sustainable way and a more democratic way, more pluralist way to make changes, but also more likely to take place given the realities of our complex system, rather than this some kind of a big bang reform measure, which will require the buy-in from a whole range of stakeholders.
right. And th- connected to that, then I have a question for you, right? If
Hmm.
given that the range of solutions that you propose require different actors to take measures, right? Some of them are within the CJI's control. Some of them will perhaps require the high courts and the Supreme Court to work together. Some of them are within the legislative's domain. If you had to pick, some of the solutions you have proposed in the book, one solution that you hope the judiciary takes forward, which one would that be?
I think two interconnected solutions. So one A and one B.
Hmm,
One A would be setting up a permanent constitution bench. In fact, I would go further than what we've said in the book and say a permanent
hmm,
constitution division of the Supreme Court, which functions the year around. It takes care of some of the problems of the master of the roster, but it takes care of something very crucial, which is that because the Supreme Court is so burdened with cases, and cases are so delayed in any case, it gives the Supreme Court an easy way out when it doesn't want to decide politically sensitive cases. And we've
hmm,
seen, again, the arguments on Article 370, the abrogation of 370 just concluded 4 years after the
hmm,
abrogation took place. On things like electoral bonds, we discussed that in the book. Even though the Supreme Court itself has said that this is one of the most consequential issues for our democracy, the court hasn't even found time to begin hearing the matter. So there, and many, many, many more such pending matters, which the Supreme Court can get away with by saying that we
hmm,
have so many cases and all cases are delayed, and this is just adding to the delay of cases. So in that sense, a permanent bench or a permanent division would makes a lot of sense. And one B of that is to rationalize the SLP system. In fact, I mean, that's a point that I think we kept coming back to repeatedly
Right.
when we're talking about people's court, when we're talking about delays and evasions, the power of the senior advocates, the administrative powers of the chief justice, which have changed exponentially from when from what it was in 1950. All of that is coming from the fact that the court is just taking on so many matters through that SLP jurisdiction, which it needn't. And that doesn't matter. That doesn't mean that the court will take on lesser matters. It's just a call for a more, a better filtering mechanism, right? It might be that the court needs to take on more SLPs, not less. But the problem with that is that currently the court has no guidelines. It depends on each judge, each bench of two judges on sitting on a Monday or a Friday on what matter they think is merits taking on or does not merit taking on. There is no standard or guideline by which they have to sort of even think through their decision. And that is allowing for a lot of matters to come in, which ultimately the court decides it was actually absolutely fine in the way it was decided. There might be a bulk of other matters that can't come to the court because people cannot afford the kind of delays that you have in the court. So rationalizing the SLP system, but which means having some clear standards by virtue of which those cases are taken up, I think that will change many of the issues, or will have an impact on many of the issues that we point to in the book. But at the same time, the ability to, ultimately, this is the highest court in our constitutional system, and it is charged with making very, very important constitutional determinations, which it is not making in a timely manner. So that working of it has to be protected, perhaps by creating a separate division itself, or at least a permanent constitution bench, so that those matters can be processed in a timely manner, and the excuse cannot be that we have so many SLPs, so we can't decide on constitution bench matters.
I completely agree with you. Just to probe on that a little bit more, when you talk about a permanent constitution division, are you looking at, say, the senior most judges being mandated to handle only those cases, or is it going to be based on whenever the case comes in, and then what happens when there are matters which requires, seven judge benches, 9 judge benches? Have you had the opportunity to think about those repercussions?
Some of these would work themselves out. I mean, this is nothing that we're proposing is very out there. High courts, the charter high courts have original jurisdiction in a range of matters, right? So they have the original side and they have the appellate side. So this idea that you have distinct divisions of this sort is not something that's very unheard of even within our judicial system. The idea would be that you have at least a permanent 5-judge bench. I mean, there are, every month the Supreme Court comes out with this one pager where it talks about how many pending cases there are. And currently, if I'm not mistaken, there are about 500 odd constitution bench matters that are pending before the courts, something
Main
along those lines.
connected.
Yeah, but there's enough and more work at all times for a 5-judge bench at least. Where a division would make sense is you don't have a single bench of 5 judges. You may have a 5-judge bench, you might have in addition a 2 or a 3-judge bench, and that would depend. That composition can be fluid. That's not, I don't mean to say that the composition has to be set, but the composition can be fluid. A 3-judge bench or a 2-judge bench to look at the SLPs that are coming in or new admissions that are coming in with respect to constitution matters, etc., etc. So just to de-link the general appellate functioning of the courts and the constitutional appeals and the fresh filings, the writ petitions that are filed directly in the Supreme Court, to distinguish those separately. It may still require people to be drawn in from the SLP side to the Constitution bench side to augment the strength of the Constitution bench because you need more judges. It might require, the judges might need to recuse themselves. There might be a whole range of factors because of which the composition might need to change. But again, as long as you have those norms set out, whether it is the senior most judges who sit on the Constitution bench, that's maybe one way of doing it. Another way of doing it might be to say that, uh, whatever it is, it's a composition that's decided by the collegium, for example, at one go for the next year, or till a judge retires, in which case the collegium then sends in the next person. There are different ways one can sort of figure that out, but as long as it is
Hmm.
there for a set amount of time, and as long as it is it's not dependent just on the discretion without any kind of guidance of one single person, I think we'll be in a better position at least than we are today, in terms of where we might land up in the court's ability to enforce constitutional norms, and in particular enforce constitutional limits, rights-based limits, federalism-based limits, so on and so forth.
And if you had to make a similar wish of the government, and here I would like to prompt you, because there is this one very strong mandate that you push towards the government, which is to increase the age of retirement, right? It requires constitutional amendment. And here again, you link that with multiple issues discussed across the book. One is the equation between the senior advocates and the judges. You make an argument that given that most of the senior advocates are likely to be more experienced than the judges sitting on the bench, it is likely that they pander to their arguments. They are more likely to be favorable towards the senior advocates, given again the aura and the standing that they have at the bar. And the second argument towards increasing the age is coming from the post-retirement benefits that is now documented by data, right? There are studies. There is a study which has been very well received, which showcases that closer to the retirement, judges are likely to give pro-government decisions. Especially if the government is going to stay on, as in it cannot get more realistic and more groundbreaking than this in terms of data showcasing judges behavior. So on both these counts, you make an argument for increasing the retirement age. However, consistently, and this is something that I've heard from multiple CJIs who have retired over the last few years, they do not seem to agree with this, view that you need to increase the retirement age. Why do you think that is the case?
So on the retirement age, so I'll come separately to what my top wish list from the government will be, because it's actually somewhat different. But on the retirement age question itself, I mean, Indian Supreme Court judges are on the lower end of the spectrum globally in terms of when they retire. And if you look at the Constituent Assembly debates that are taking place when the retirement age is being set, it was very much of that moment, right? The idea that by 65, people are, this is the, they're looking at the life expectancy of Indians at that time, the ability to work beyond 65, so on and so forth. All of that has changed. In fact, I mean, judges post-retirement go on to have very robust careers, even at the Supreme Court, making, of course, many times more of their salary than they do as Supreme Court judges after they retire, as in giving legal opinions, in arbitration, so on and so forth. So it's not as if they stop practicing the law the day they retire. The only prohibition on them right now is that they can't, as Supreme Court, they can't practice in any court in India. But they continue to have very robust legal careers beyond practice in courts after this, right? Now, what we are suggesting is that if you increase the retirement age to 70, clearly now we've seen through a range of statutory sort of amendments where tribunals have been created. Judges retire at the age of they have chairpersons who are former Supreme Court judges who have tenure up to 70. There is some expectation that till up to 70 uh, Supreme Court judges can function well. The other element of this is, and this of course depends on things not changing at the initial end of when they are appointed. They will have then longer durations on the court, which means some greater stability, both in terms of jurisprudence and in terms of thinking more institutionally about the court. So those are some of apart from the reasons that you mentioned, those are some of the other reasons why we were suggesting that retirement should increase to 70. Um, that will though require some amount of rethinking about our tribunal system, because off the back of the 65-year retirement age for Supreme Court judges, we now have a whole tribunal mechanism which where many positions require, or commissions which require Supreme Court retired sitting or a retired Supreme Court judge to be heading that institution, and there the retirement age is also 70. So something will have to be done about it. And I mean, again, it's the separate conversation about what might be done there. But just to say, so therefore, this idea that 65 is when judges need to retire because then now they need to lead a retired life is not necessarily the case. The benefits might be immense. um, Supreme Court judges, like I said, go on to have very lucrative careers on the commercial side, or just in terms of giving or in arbitration or in giving legal opinions, etc. On the one hand, on the other hand, there are all these government-led committees, commissions, tribunals, etc., that they seek and get appointments to, and that creates a range of perverse incentives in terms of what of how they decide, how they may end up deciding cases towards the end of their career, which the fantastic study by Dam Ane and co that you already mentioned has very clearly shown. So I mean, to us, therefore, there seems to be there are lots of positives to having this kind of a high retirement age. But my ask for the government, if I had to one thing on that wish list, would be litigation policy which takes away the decision on whether to appeal a matter from the officer who's most directly involved in the case to the law officers of the government. Because one thing that we found is that the government has over appeals, right? The government's track record of the cases that that have been admitted in the Supreme Court, the revenue, for example, does an incredibly poor job of bringing cases, because it has 50% of less of a chance of actually winning a case in the Supreme Court. This is of the matters that have been admitted. You can imagine the whole range of matters that the Supreme Court doesn't even admit, right? So it has a very, very poor track record of winning cases in the court. It just appears that it is over appealing and is bringing very poor cases, and so therefore it's not really winning those cases. Similarly, on the criminal side, etc. So therefore, when we spoke to officials, we were told that the concern is that if I don't file an appeal and someone higher up thinks that an appeal should have been filed, then there might be allegations of corruption that are made against me, or at least I might be sanctioned in different ways, which requires that there should be a legal sort of scrutiny of that file to see if there are good grounds to appeal, taken away from the people who are most closely involved in that decision making, and sending it off to the government, whatever government's lawyers, the law officers, to take a call on whether that appeal should be filed, or any other legal department, so on and so forth. So just to say that that kind of a barrier where decisions are made on the basis of the legal strength of the case and not on these sort of other kind of extraneous reasons is taken away, will hopefully reduce the number of cases that the appeals that the government is bringing. Obviously has all the advantages of certainty, etc., but in that individual given case, but also the government is by far the biggest litigant before the Supreme Court. And so if you reduce the number of cases that the government is bringing, that is obviously likely to have a range of other good impacts down the line.
Completely agree. I'm glad you brought this up. And I'm glad that the official you spoke to actually highlighted this as a problem, because just to share my experience with dealing with government litigation, when we took this to a senior government official, the reaction was, what is the problem? Government is paying for the judiciary to function. Obviously, government will take its cases to the judiciary. So it was almost relegated as a non-issue. So I'm glad whoever you spoke to at least wanted to see how things can be worked around. And as you rightly said, you tackle the problem of government litigation first by understanding what these litigation is comprised of. And even in that, the book does go into looking at whether it is service matters, tax matters, appeals, so on and so forth. And also looking at government at both sides of the equation, right? Some of them are filed by the government, some of them are filed against the government. Now, the ones that are filed by the government is where the government can actually take some hard decisions by empowering their own officials to mediate, to arbitrate. For so long, the government has been pushing for ADR. If it practices what it preaches, I think there will be a huge reduction in the court's burden and speedier disposal of cases for its own employees. Because as we have seen, it is the service matters that end up in courts. And recently, one of the high courts has also imposed fines. So I think both the government and the judiciary have to take on that mandate now to effectively reduce government litigation for their own good. And hopefully that will happen. But I don't want to end on this note. I want to see, what you have planned for the future. Is there part two of the study in the works, especially now that there is more data available and more easily available? We, of course, have to check the quality of it. Supreme Court has recently come on to NJDG, a decade late, I would say, but it is there. And it is easier to now run those tests and perhaps put together the data sets that you all painstakingly have over the last decade. It might take lesser time to do that. So is that in the works, or do you want to focus on other tiers of the judiciary? If you can shed some light on that.
Sure. So just on NGDC, I should say I checked it on the day on which it went live. But my sense was, and I haven't checked it since then, but my sense, at least on that day, was that you were getting aggregate pictures and the ability to drill down to case level information wasn't there. And then if you're just getting aggregate pictures, then that's not going to help the kind of sort of detailed work that we were doing, which required disaggregated case level data. So I'm just waiting to see, perhaps, things might have already changed, or perhaps the court will put in more information as it goes forward, and we'll wait on that. I have one project that's already in the works, another that I'm hoping to begin. One is I'm working with a few colleagues over at the Data Development Lab, and we've got some funding from India and from Switzerland on looking at trial court data, and the work that I will be focusing on with my team here at National Law School is looking at criminal law data to use the tools of AI, since we were talking about that, to look at these orders and think about how is bail jurisprudence developing, what are the grounds on which bail is being granted, how long are cases taking, so on and so forth. So we have a range of questions that we want to answer through studying of these orders, which again is now available to us. It's something that we can do, and we're thinking about like millions, right? So the Data Development Lab data set is about 80 million cases. So that's the kind of sort of volume that we're looking at. and we can do that using tools of AI. So there is that work that's just about to kick off. The other thing is to look at, and this another colleague of mine, Rangin Tripathi, who's at NLU Orissa, he and I are again in initial conversations to now start looking at again AI driven tools to study orders of the Supreme Court. So when we did that for this book, we had to hand code every judgment along various parameters. Now that AI related tools are available and we have standardized texts on which we can run this kind of these kinds of tools, the hope is to be able to do that for Supreme Court judgments, and then ask again another set of interesting questions on what it is that the courts are doing, update the kind of data that we've already gathered, but also see if there are other questions that we can ask that we just couldn't ask because we were hand coding every case.
That sounds very exciting. Looking forward to that already. And with that, we are up for time. But in case anyone wants to ask any last few questions, happy to take that. Otherwise, I will close this, and I will start with thanking our attendees who decided to spend their Wednesday evening with us. Thank you so much. Shireen tells me that there are questions in the chat window, which I unfortunately cannot see. I can see one which references being mentioned as significant precedents or examples. I think we can provide for that in the description of the video that we put out on YouTube. We will try and do that, Mr. Azam, who has posted this comment. But Aparna, thank you so much for having this discussion, giving us a detailed overview of all the findings, all the data points that you have covered with your co-authors in the book. It was a real pleasure, very insightful. And I will continue to have this conversation offline and pick your brains also on the new studies that you will be undertaking. Thank you once again. Thanks
Thank you
also
so much,
to
Deepika.
and Atul, our interpreters. Thank you so much. Have a good evening and good night, everyone.
Thank you.
Thank you so much, Preeti. And Amit ji, I don't know अगर अमित जी अभी भी हैं.